Now, for the detailed reasons which will be published on a date to be advised next week, the originating application, which was filed on the 2nd of December by both ASADA and the AFL, fails in all respects. I'll hand out some notes. Have you got some? I think we've got some notes which we'll hand out to people if that's helpful. Oh, all right. Briefly, the application fails for a variety of reasons which flow from a number of findings I make, including that 1, proceedings before the AFL Anti-Doping Tribunal are not properly characterised as arbitration proceedings. 2, if which in my opinion is not the case, these proceedings were properly characterised as arbitration proceedings, they are not properly characterised as commercial arbitration proceedings to which the Commercial Arbitration Act 2011 applies. And 3, there are no proceedings which are either expressly provided for under any other legislation, such as the ASADA Act or the regulations under that Act, or proceedings which are properly characterised as arbitration proceedings under such legislation which would attract the operation of subsection 1(6) of the Commercial Arbitration Act. So it follows that the provisions of section 27A of the Commercial Arbitration Act, which are relied upon for the purpose of the application, do not apply. So there's no basis for the issue of the subpoenas. Now, there are a number of other issues which will be addressed in the reasons, but it's not necessary to deal with those now, as they won't affect the outcome. Now, the question of costs is reserved, subject to further submissions, and the applicants are to bring in orders to give effect to this judgment. Mr. Starr.